Hello? Can you hear us?
Yes, ma'am. I'll be with you in just a moment.
Okay, great.
I'm not.
You're at the jail stand.
So both the lawyers are going to be up there.
Okay, there I am.
All right, Mr. Knoll, how are you today?
A little overworked today, but last few days, but I'm okay.
All right, well, court's going to call cause number CR 2156, State versus Robert Cecil Crane Jr. via Zoom from Wood County. I believe we're set for a pretrial today.
Okay. I think that is correct. I don't, well, I've been trying to settle 4 felonies that might have been going to trial Monday. We just got through getting paperwork done on those cases. I meant to try to call the DA's office in Wood County to find out the status of the cases there. I never got around to being able to have the time to do that. And when I finally made a call, the person I needed to talk to about those cases wasn't available. So I don't have any pre-trial in this case. I just don't know the status of the Wood County cases. And I don't know if the DA's office in Van Zandt has been able to find out anything.
So what do I?
Judge, I'm sorry, this is Ms. Heisel's case. I'm unaware of the situation with Mr. Crane in Wood County. And I don't see any notes in his case that indicate otherwise.
Judge, all I recall about it is there is a similar charge as to the charge in Van Zandt County, and then I think it's 2 assault on public servant charges that are also pending over there. So he has 3 felonies pending, if my memory serves me correctly, in Wood County.
Okay, but there are no pretrial issues in this Van Zandt County case.
No, Your Honor.
All right, then let's set Mr. Crane for docket call. And let's set him in October. And the dates I have available, Mr. Knoll, are October 11th, 13th, or 25th.
Judge, I actually filed a vacation letter, that's probably just done whatever day I was there. What day was, well, that was yesterday. uh, For the end of October, so it need to be in the first part of October. And I have no idea, and I'll try to find that out on any scheduling in Wood County for Mr. Crane.
So are you available on October 11th?
That'd be fine, Judge.
Court set docket call on October 11th. That will be at 1:30 if Mr. Crane is still in custody. And we'll coordinate with Wood County about having him available for another Zoom hearing that day.
And I'll try to check with Wood County before the day's over sometime this week, so we have more information on that.
All right. Thank you, Mr. Knoll. Thank you, Mr. Crane. Y'all have a good day.
Yes, sir, you too.
You're welcome. Tell Wood County staff I appreciate their help in setting up Zoom.
Yes, sir.
Thank you, sir. Deputy McLeish, is Mr. Schmidt there and available for Mr. Ledbetter?
Your Honor, Mr. Schmidt, I have not seen him at all this afternoon.
Yeah, he told me he may be a few minutes late, so spoke with him earlier. So, Mr. Ledbetter, your attorney's on his way. He's running a few minutes late to court. So as soon as he gets here, we'll have your hearing. Okay. All right. All right. Do we have any other counsel that's out there ready to go?
Your Honor, we do have Miss Lee here. Miss Lee, come on up. Sir, come on up with her. Yes, sir.
All right, this is cause number CR 22-178, State versus Mitchell Gilbert, set for arraignment today. Ms. Lee, go ahead.
I'm present here for the arraignment, Your Honor, of Mr. Gilbert.
Yes, ma'am, you can proceed.
I'm sorry, I'm not remembering if there's what else I'm supposed to. Oh, he pleads not guilty, Your Honor.
Okay. Have you reviewed the indictment with him?
Yes, I have, Your Honor.
Is his name spelled correctly?
Yes, it is, Your Honor.
And does he understand what he's charged with?
Yes, he does, Your Honor.
All right, and you already said that his name is spelled correctly. So and you indicated that Mr. Gilbert is pleading not guilty.
Yes, I am.
All right, court will enter Mr. Gilbert's plea of not guilty into the record, find that he waives the formal requirements of arraignment. We'll set this matter for pretrial hearing. And we'll set this, are you available on either September 20th or 22nd, Ms. Lee?
Just a moment, Your Honor. September, is it 20th or 22nd?
Correct.
Yes, I'm available either day, Your Honor.
Do you prefer either one?
September 20th, Your Honor.
Okay. All right, court set Mr. Gilbert for pretrial on September 20th. That will be at 1:30. If Mr. Gilbert is still incarcerated, it'll be 9 a.m. if you make bail, Mr. Gilbert. All right. So if you are on bail before your next hearing, then hearing will be at 9 o'clock in the courthouse. Okay.
Yes, sir. Thank you.
All right. You're welcome. All right. If there's nothing further, we'll be adjourned in Mr. Gilbert's hearing.
Thank you, Your Honor.
Your Honor, we have nobody else ready at the moment, but we do have a couple who are working.
Okay. All right. Thank you, ma'am. I appreciate it. Deputy, please.
Yes, Your Honor, we do have a couple that are ready right now. We have Mr. Weiner with the plea, and we have Mr. Stevens with a quick appearance.
All right, good afternoon, Mr. Weiner.
Good
All
afternoon,
right.
Judge.
Court calls cause number CR 21-320, State of Texas versus Ashley Blair. Ms. Blair, if you'll raise your right hand, I'm going to place you under oath, ma'am. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Just continue speaking up loudly and clearly for me so I can hear you and so we can take down what's being said, okay?
Yes, sir.
All right, Ms. Blair, is your name Ashley Blair?
Yes.
And Judge, actually, real quick, I'm sorry to interrupt you, but before we start the plea, and I didn't get a chance to tell the state about this, but there is a typo that I just found in the indictment that I think if we could just make a like a trial amendment. It's the second paragraph, the second sentence reads in that on the 30th day of jury, and it's supposed to be July. And so again, I apologize for interrupting you, Judge, but if we could just amend that, we'll be ready to go.
Okay. And Mr. Woodwhite, or do you want to make a oral motion to amend the indictment to correct the language that Mr. Weiner has pointed out?
Yes, Judge, I would so move.
All right, court will grant the motion to amend the indictment to reflect in the second paragraph, second sentence, 30th day of July 2013. Court will strike the word jury and insert July on the original charging instrument. I appreciate you bringing that to my attention, Mr. Weiner.
Thank you, Your Honor.
Thank you, Judge.
All right, Ms. Blair, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And Ms. Blair, have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar, PTSD, and schizophrenia.
Ms. Blair,
He's
are you
under-
on?
Judge,
Okay, say that again. I couldn't hear you.
I'm sorry. Technology. She received medication and care for the Injury Center in Athens.
Is she currently under treatment or care or medication for those disorders?
Are they giving you medication in jail? Okay, how long have you been taking it?
Since I got here. Well, I started back in May. But
Okay,
I've been on medications.
and they've been giving them to you regularly, and you feel like you understand what's going on today? I believe she's confident, Judge.
Okay, and so Ms. Blair, you feel like you have a rational understanding of the proceedings as they are going on here today?
Yes, sir.
All right, thank you. All right, and so the court will note Mr. Weiner's statement that he believes that his client, Ms. Ashley Blair, is competent today. Mr. Weiner, have you advised Ms. Blair as to her rights as it pertains to this case? If so, do you believe she understands them?
I do, Your Honor, and I represented her for a length of time. I feel like the entire duration, she has understood and be able to assist me in potential defenses and has a functional understanding of what she's doing today, Judge.
And on the judgment, I see that the attorney for the defendant states Mr. Mike Head. Is that true and correct, or does that need to be changed?
Judge, I guess my running joke is we're kind of interchangeable. I believe he's the actual attorney of record, but I've been the one that's handling the case, Judge. So I think it's perfectly fine.
Okay. All right, Ms. Blair, you are charged by indictment with a state jail felony offense of theft of property less than $2,500 with 2 or more previous convictions. In addition, the state had filed an enhancement paragraph that, if proven true, would enhance your range of punishment to that of a 3rd-degree felony, which would carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice. Do you understand that full range of punishment, ma'am?
Yes, sir.
Okay. And I see in the plea agreement here that you would plead guilty to that charge. You would also be pleading true to each of the enhancement paragraphs in exchange for the state's recommendation that your punishment be assessed at 4 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on probation for a period of 8 years with a $1,000 fine plus restitution in the amount of $1,195.58 with court costs of $290 and reimbursement fees of $85. Is that the plea agreement as you understand it, Ms. Blair?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
All right, then let me ask you at this time, Ms. Blair, how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
And Ms. Blair, as to the enhancement paragraphs alleged in the indictment, are each of those enhancement paragraphs true or not true?
True.
And that's true to both enhancement paragraphs, is that correct?
Yes, sir.
All right, court will. Well, let me ask you this, Ms. Blair. Has anyone threatened, forced, or pressured you to plead guilty or true to this primary crime or the enhancements?
No, sir.
Court will accept the defendant's plea of guilt and also plea of true as indicated. Mr. Weiner, any objection to the state's evidence?
We have no objections to the offer.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense, Mr. Weiner?
Rest and close as well, Judge.
All right, court will review the evidence briefly. All right, court has reviewed the evidence and I do find sufficient evidence to convict Ms. Blair of this offense. Court will convict Ashley Blair of theft of property less than $2,500 with 2 or more previous convictions. Court will find the enhancement paragraph to be true. Court hereby assesses her sentence at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence, place her on community supervision for 8 years. Order her to pay a $1,000 fine, restitution, $1,195.58, $290 court cost, and $85 reimbursement fees. Ms. Blair, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be fingerprinted, after which you'll speak with the probation officers.
Thank you.
Thank you.
Thank you, Judge. That's all I have. May I be excused?
Yes, thank you, Mr. Weiner. Good to see you.
See you.
Yes,
Mr. Schmidt, are you ready for Mr. Ledbetter?
I am, Judge. Do you want to take Mr. Stevens first?
No, no, I need to take Mr. Ledbetter because he's on loan to us from Kaufman County.
Yes, sir. Yes, sir.
All right, Mr. Ledbetter, can you have, is there a jail staff person in the room with you, Mr. Ledbetter? Can you ask them? There you, thank you. I was gonna ask them to unmute. They read my mind. All right, Mr. Ledbetter, can you see and hear me and Mr. Schmidt okay?
Yes, sir, I can.
Excellent. Okay. All right. This is cause number CR 22-186, CR 22-187, and writ WR 22-67. Let's take up the arraignments on the criminal cases. Mr. Schmidt first.
Judge, as it pertains to both of those cases, I've received a copy of the indictment. Me and Mr. Ledbetter have discussed them. His name's spelled correctly. We wait for him reading on both, enter a plea of not guilty, ask they be set for pretrial.
All right, court
On
will
that.
920.
Yes, sir.
All right, court will find that Mr. Ledbetter has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record for each cause respectively, and the court will set each matter for pretrial hearing on September 20th. That will be at 1:30 if Mr. Ledbetter is incarcerated, 9 a.m. if he's on bail. All right, so let's take up the writ WR 22-67.
Judge, if I may address the court on that issue. We have, in this county, Mr. Ledbetter has I believe one or two felony charges that are unindicted. We filed a 17-151. Obviously, he's being held in Kaufman County as well. At this point in time, we've had some new developments on his indicted cases here, which I found out just a few minutes ago that the bondsman has released surety on those. And so at this point in time, what I'd ask the court to do is allow me to abate the writ, not to close it out, but to abate it to a later date. So I'll have an opportunity to discuss with Mr. Ledbetter the collateral consequences of pursuing it, given the fact that he's got other issues on a release at this point in time.
Okay. All right. Court will grant that request, and when it's ripe to be said again, you'll just notify Ms. Taberham and we can get it put back on the docket.
Yes, sir. And I'd ask that Mr. Ledbetter contact my office or through his wife on Friday.
Did you hear that, Mr. Ledbetter?
Yes, sir, I did.
Okay. All right. Anything further for Mr. Ledbetter's case, Mr. Schmidt?
No, sir.
All right, Mr. Ledbetter, we'll see you back on September 20th. If you make bail in this case, then your hearings will be at 9 a.m. in the courthouse. All right. And if not, then if you're in the Kaufman County Jail, we'll contact and ask for Zoom, or if you're in the Van Zandt County Jail, then we'll make it happen at 1:30. Okay.
Thank you so much, Judge.
All right. You're very welcome. And thank you to the Kaufman County detention staff for assisting us. Sorry for the delay in this today.
You're okay. Thank you, Judge.
You're welcome. You have a good day.
You too.
All right, Mr. Stevens.
Good afternoon, Judge.
Good afternoon. Sorry for bumping you there.
Hey, that's no problem.
Mr. Schmidt sent me a text and told me that he was going to go first, whether you wanted him to or not. So I told him
He was going to strong arm me if I didn't. But I am a young.
I'm teasing. All right, this is cause number CR 20338, State of Texas versus April Marie Grant, set for pretrial. Go ahead, Mr. Stevens.
Yes, Your Honor. A couple of issues. Last time we were in court, we reset it. It was my understanding there was 2 or 3 new charges that were going to come down against her. I haven't seen anything on those yet. And on this particular cause we're in front of the court on today, I have the lab submission report and the offense report, but I don't have an actual copy of the lab report. So what I would respectfully ask the court is if I could reset this pretrial to another pretrial setting and get with the prosecutor about these additional charges that I was told about anyway back in, I think, June.
Mr. Woodward.
Judge, we will absolutely open everything we have to Mr. Stevens on CR 20-00338. I was unaware that he didn't have it. As far as the charges from April, it looks as though we are awaiting the Department of Public Safety drug lab on the felony, and there are a number of misdemeanor charges that we will review as well. So I will open up discovery on all of these charges so Mr. Stevens can have a clear view of everything that we have. I was unaware that he did not have the lab report in this indicted case. I'll make sure that's open today.
Okay, and I'm sorry, I'll get with you sometime next week and maybe try to work something out or get an offer from you.
All right, Mr. Stevens, are you available on September 20th or 22nd?
Judge, on vacation on the 20th, the 22nd, I'll be back. I've got several cases in the 392nd at 1:30. I can still do this, but maybe by like 3 to 4 o'clock before I could probably get here, sir.
What about the 27th?
I got the same issue, 6 that afternoon.
You got 6, so you got more stuff on the 27th than you do on the 22nd.
I've got fewer on the 27th. I think I'll be out of Kaufman quicker on the 27th than I would be out of Henderson County on the 22nd.
Okay, so you're saying say that again. You'll be out of Coppin quicker on which day?
On the 27th.
So you'd rather be set it for the 27th?
Yes, sir. If you wouldn't mind, for say 3 o'clock, I think I could make it by then, Judge.
All right, we're just gonna set it for 1:30, and then you'll get here when you get here, and we'll just look. at it. All right, so we're gonna set Ms. Grant then for additional pretrial on Tuesday, September 27th at 1:30. And if you wanted to come to my court first and then go to their court, I wouldn't be upset at you or anything. So,
Judge, I could do that too if I had something worked out where I can get it out real fast. Okay,
so you get here early, we'll get you called early.
sounds like a plan, Judge.
All right. Is that all you got, Mr. Stevens?
Yes, sir, it is.
All right, have a good day.
Thank you, too, Judge. Signature.
Mr. Schmidt, you have any more that are ready?
Ready on all of them, Judge.
All right, let's start at the top. All of your clients in here?
I'm sorry, sir, I didn't hear that.
Are all of your clients in there?
All but Mr. Gerard.
Jonathan Bergen, CR 22-172. Mr. Bergen set for pretrial.
That's correct, Judge. We don't have any contested pretrial motions asked for a docket call on 9/20.
All right, there being no contested pretrials, court sets docket call September 20th at 1:30 if he's incarcerated, 9 a.m. if he's on bail. Jennifer Culpepper.
Judge, I'm sorry. This is, she's not in here. She's still in there. So if we could do the mails, say Gerard.
Leonard Purley. Mr. Purley set for docket call CR 21-234.
That's correct, Judge. And I asked, we reached an agreement with the state, asked that be set for a plea this Thursday.
All right, court will set Mr. Purley for a plea on August 11th. Well, hang on, let me check on that real quick, Mr. Schmidt. Is it for time or probation, or what is it?
Time served, Judge.
Time served. All right, I'm gonna set it for Thursday, but we're going to move quickly because I have to be gone relatively quickly. I had to be gone by 3 p.m. on Thursday.
Make it happen, Judge.
So we'll set it. It's going to make about 74 cases for that day with probably in the afternoon. So I'll just have to state how the paperwork ready and we'll move quickly.
We'll get it done in short order, Judge.
Thanks, sir. David Lee Phillips, CR 21-305, pretrial.
That's correct, Judge. At this point in time, I don't have any contested pretrial on Mr. Phillips. That may change. I'd ask the court permission for leave to file late pretrial motions in the event it becomes necessary. But for today's purposes, we'd ask it be set on that 8/20 docket call.
All right, court will set Mr. Phillips for docket call on September 20th at 1:30. Court will grant the motion for leave to file late motions should it become necessary. Skylar Tanner. CR 2312, motion to revoke.
It is, Judge. I do believe that ultimately, we will reach an agreement with the state. However, if we could set Mr. Tanner on the next contested or evidentiary docket for his motion, hopefully at that time we present an agreement to the court.
All right, court will set Mr. Tanner for contested hearing on August 25th. You can either enter an agreement that day, or we can have a hearing on the motion. So you're waiting on Mr. Gerard and Ms. Culpepper, correct?
Correct, but I do have Mr. London, the court appointed in that case.
Oh, yes. All right. Mahar Hamdan, CR 1576. All right. For the record, the court had appointed the Honorable Casey Chester to represent Mr. Hamdan on the state's motion. The court knows that Ms. Chester, Sirianni now, I believe, is on maternity leave, and so the court has removed her as counsel and appointed the Honorable Richard Schmidt for representation. And I understand, Mr. Schmidt, you just were appointed today, so we will reset this to September 20th unless you have a different request. Or a matter of fact, we could set it for the contested on September 29th, and then that would give you some time to.
Do you have space on your contested and on that August, what did you say, August 25th?
August 25th. Yes, sir, I do.
If we can do that, that way I can hopefully expedite. And if something comes up, we can ask the court to bump it since
Okay.
he's in custody.
All right, court will set Mr. Hamdan then for August 25th at 1:30. Deputy McLeish, do we have Jorge Amador?
We do, Your Honor.
All right, I have Mr. Linder online, so.
Hey there. Your Honor.
Yes, good afternoon, Mr. Linder. All right, this is cause number CR 22-232, 233, 234, State versus Jorge Eduardo Amador, and we are set for arraignment in each one of his causes. Mr. Linder, have you gone over the indictments with your client?
I have. We did about 2 weeks ago. I was there at the jail and met with him.
All right, you can proceed.
Well, I don't know how this court normally proceeds, but at this point, we would like to waive formal arraignment, enter pleas of not guilty. We're going to be meeting with the DA going forward to try to figure out how to proceed.
Okay. Is his name spelled correctly in the indictment?
I believe so. It was when I went over that I had with him. Yes.
Okay. All right. And he enters pleas of not guilty to each charge, correct?
Yes, sir.
All right. Court will find that Mr. Amador has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record for each cause respectively, and we will set this matter for a pretrial hearing. Mr. Linder, I'm setting hearings on September 20th and 22nd. Do you have a preference on one of those dates?
Quite funny. I've got I represent Stuart Rhodes, the founder of Oath Keepers, in one of those January 6th insurrection cases in Washington, DC. We start January 14th or September 14th, and it's supposed to last about 5 or 6 weeks. If I could go to beyond that, that'd be great. And then that'll give the DA and I more time to visit before I leave for DC.
First date I would have after that would be October 25th.
Let's try that. If for some reason I can't make it back, I will have one of my associates be there. I appreciate the flexibility.
Okay. Well, do you have an associate that could stand in for you sooner than that time? I hate to set it out 60 days with them being in custody.
Would the next arraignment be would it be by Zoom also?
I would permit the pretrial being by Zoom, and what I'm looking for on the pretrial hearings is any contested motions being announced, and if there's a motion to suppress, quash, something of that nature, pretrial issues, we would take those up. I could allow you to appear, or your associate to appear via Zoom.
Yeah. So when would that be? That would be September when again?
Either September 20th, 22nd, or 27th.
I would, let me just kind of see September. That 27th, that Tuesday is probably better. It's the furthest out. That'd be great for me.
Okay, then I'd feel better about it with him being in custody, and that will give the state opportunity to make sure you have all the discovery. And then that's just the, statutory deadline to file any contested pretrial motions. If there are no contested pretrial motions, the rules of this court, or after that, I would just set you for a docket call about another 30 days out. And that would give you all an opportunity to determine whether or not there's going to be a plea agreement or a request for bench trial or jury trial.
Okay, thank you very much. And what time that day on the 27th would it be?
It'll be 1:30. As long as Mr. Amador is in custody, the hearings will be at 1:30. If he ever makes bail, it would be at 9.
Got it. Okay, thank you very much, Your Honor.
You're very welcome. All right, I will mark this down on my docket, September 27th for pretrial in each case. All right, thank you, Mr. Andrew.
Thanks, sir.
Yes. Your Honor, are you ready for Smith?
Yes, ma'am.
Ms. Culpepper?
Culpepper. CR 21-352, Jennifer Jerry Culpepper, docket call.
That's correct, Judge. We're not ready to make an announcement. I think we're still negotiating with the state. I don't know how many docket calls she's had. It hasn't been many. We'd asked that we're getting a big call, set her on that 920 docket. Hopefully we can resolve this by then.
Any objection from the state?
State would be unopposed, Your Honor.
All right, court will set Ms. Culpepper for a final docket call on September 20th. Is this Ms. Rogers?
It is, sir.
Brianna Rogers, CR 21-236, motion to revoke. You want me to set her on that 8:25 docket?
I do, Judge. And if we can resolve it, we can. If we can't, we'd ask for an additional 7. I'm hoping.
All right, court sets Ms. Rogers for the test hearing on August 25th at 1:30.
Your Honor, Mr. Trump is supposed to be on his way up, but he's not quite here. So if we could have just another couple moments, please.
I'm not sure. There's a lot of feedback. Can you say that again? I didn't really hear what you had to say.
We'll disregard.
Okay.
Mr. Gerard, come on up, sir.
CR 2267, Robert Gerard, set for pretrial.
That's correct, Judge. We're going to ask for an additional pretrial. I obtained the court's permission to make some expenditures on Mr. Gerard's behalf. And he and I are in the process of getting that set up. I intend we're going to meet on Monday on some of these extraneous issues. And hopefully we'll be able to wrap up our pretrial issues before our next court. But at this point, we would ask for additional pretrial.
September 20th. All right, court will set Mr. Gerard then for additional pretrial on September 20th at 1:30.
Your Honor, I believe we're done here at the jail. Am I correct?
It does appear that way. Just
Anything else we can do for you before we sign out?
not that we can accomplish in one afternoon, so we'll leave it at that.
Thank you, sir.